First of all, we are here for achieving some goal. What is the goal? Goal to achieve the best. And how it comes? Through the happiness. What is happiness? What is happiness? Anybody? Roughly, what is happiness? What is that? Happiness. कैसे? इस पेन पे अच्छा आ गया? What is happiness? All things starts from here in the life. That is with regard to goal. I may tell you happiness in few words. Happiness means doing well and living well. What is that? Doing well and living well. And it reflects in the moral and the ethical laws. And all our statutory laws and executive laws and policies and judicial legislation according to the happiness and the goals. Followed? How this happiness comes? When you do well. When you will do well for achieving some goodness in life. Once you understand the happiness, you start to take the things seriously in your life to do. Followed my point? Understand all happiness. Today let us, brothers, we start offense. How the criminal machinery is set into motion. I told you, you let me know in brief. Mr. Last. Yes, how? What are the methods? Suppose an offense is committed. What you will do? Number one, I told you on that day, whether you will make a call to the PCR. Yes. They will refer it to the jurisdiction. They will enter the DD entry. Then it starts. Every action starts from there. That DD entry is assigned to a police officer. And who is police officer? Who is police officer? Head constable and above that. Police officer, because the powers of investigation and inquiry has been conferred on the police officer. Followed my point? This is very basic thing, you must understand it. Assign the DD entry to the police officer. Police officer goes to the scene of crime. He collects the information. You must know about the information. What is information? What is information? What is information? A collection of facts. A collection of facts is information. Now we may start difference between the inquiry, investigation and trial. After collection of facts, what they do? They inquire the matter. And what is inquiry? Inquiry is collection of information. Inquiry is collection of information. It can be snap inquiry, it can be preliminary inquiry. Okay? On the basis of that information, when it is examined by the authorities, police officer, whether the offence is committed or not, then an FIR is registered. If it is a cognizable offence, if it does not disclose cognizable offence, then no FIR is registered. Only entry under section 155 of the register is made, and then investigation can only be directed by the magistrate. Police has no role, just they will enter the particulars.
What is cognizable and non-cognizable?
Cognizable and non-cognizable. How you will come to know cognizable and non-cognizable? Very good question. Cognizable means the police authority has the power to investigate and to arrest the person in the cognizable offence. Yes, without warrant they can arrest. Warrant is required from the court of magistrates. In the cognizable offences also, they can arrest you. They can detain you for 24 hours. No problem. That is detention. Before arrest, it comes detention. They can detain you for inquiry, for your examination. Okay? And cognizable, non-cognizable, these are given in Schedule 1. We find out from there which offence is cognizable, which is non-cognizable. When offence are non-cognizable, these are most of the offences are serious offences. Police officer has power to arrest without warrant. They can arrest you, they can detain you for any purpose, inquiry, investigation after recording of FIR, registration of FIR, and inquiry before registration of, because the nature of the duty is administrative, and administration grants the discretion. Which offence, how they will record, what method they will adopt, these are not given. These are not given. These are the discretionary steps. How they will collect the information, whom they will call, what they will do. If suppose you go to the police station and they don't record the FIR according to you, it is an offence. You can file an application under section 156(3) to direct the authority to register a case, FIR. They can register. After registration, investigation starts. What is investigation? Roughly anybody can tell. What is investigation? Huh? That is not evidence. That is collection of information and examination of that information and observation. That is investigation. That is collection of information, examination and observation. This is investigation. And after investigation, challan is filed in the court under section 173. Thereafter, as per the usual practice, magistrate, whether the cognizance is required to be taken or not, it is the prerogative of the magistrate. What he will do, whether he will issue the process, whether he will call you or not, it is his prerogative. Thereafter, after the first appearance or produced from the custody, he will supply you the copies. If he calls you, issue the process. He will supply the copies under section 207 207 CRPC, and if any deficit copies after examination of the record, you can file an application to obtain the same from the magistrate. But most of the time what happened? In the CFSL reports are not received. Documents are not complete. Then argument comes before the court. The copies have not been supplied. How you can hear the argument on charge? Then this become a very disputed point, and advocate address the arguments on that. He will say the copies have not been supplied. How you can hear the argument on the charge? Before charge, it is all inquiry in the court. It is a court inquiry. So long as trial is concerned, after framing of charge, the trial starts. And in the trial, what happens?
So what is charge? Charge came.
Charge means explanation of offense to the accused. We ask whether you plead guilty or not guilty. If he pleads guilty, immediately judge convict him and fix for argument on sentence directly. But he will. One important question: can accused can be a witness in his own case? Be a witness in his own case. Accused can be a competent witness under section 315 of the CRPC, subject to the condition he will take the permission from the trial court. He is a competent witness. He can explain the facts himself also in his defense, but he will have to seek the permission of the court. This is a very important section, I am telling you, and most of the good lawyers for their accused use. Because when the police files a challan, they record the statements, they file the statements which are against the accused. But some statements are recorded by them in favor of the accused also. Whether they are filed with the challan, then where they go? Where these statements go then? Those statements are kept in VRK branch. So those who are smart lawyers and having good experience, they call the records from the VRK branch. Bring the statement of that person. Then they get it recorded. In the defense, they can call for the cross-examination also. So these are the very basic things which you can summarize, you can understand, because these are the intricacies of the process. These are not known through the books. This comes through the practical experience. But the usually question can come to you in the exam. Whether accused can be a competent witness. It can be in the prelim also. It can be in the main also. This is very important. And now this has been started by the council to use this section frequently. Because new things have come, new technologies have come. Therefore, police records every statement, so many statements. What they do? Only they use the information which is against the accused. They don't file with the challan, which is whether the recording of statement under section 160 is mandatory while filing the challan. Let me know. Anybody? Tell me anybody. It is not mandatory. Police, it is not mandatory for them to record the statements under section 160, and they can file the simply name of the witnesses. No need at all to record the statement under section 160. They will call them, they will examine them. it is sufficient. It is not in the books. It is not in the books. It is a practice. How I came to know this practice? There was a case of some cabaret dance. What the police did, what they did, because they exercised their influence. What the police did, they did not record any statement. And about 20 girls were caught from there. They did not record a statement of any person. They simply recorded the names of the witnesses. I was surprised to see there is no statement. How the trial will start? Who will then the matter was argued at length. Then we came to know that the statement is not mandatory under section 161 CRPC. They can simply produce the witness and they can examine it. It will be used either for the conviction or for the trial or for the cross-examination whatsoever. Okay? Bailable, non-bailable तो आपको पता है शेड्यूल में. Everybody knows about the schedule. Bailable, non-bailable, cognizable, non-cognizable. These are given in schedule. Schedule 1 CRPC refers to the bailable, non-bailable, cognizable, non-cognizable, sentence and trial by whom. ये schedule में दे रखा है. But this is given in schedule 1 about the IPC. What about the other offences? Other offences are also there. Outside the IPC, there are number of criminal cases. How you will find those? Which is cognizable, which is not cognizable? Anybody? Any idea?
Last entry.
Huh?
Lastfully entry. Schedule में lastfully entry.
No. Schedule 2. Schedule 2, because I remember a case, Gambling Act ka. That is, perhaps it was, you see, non-cognizable whatsoever like this. A person came for argument. I did not grant him bail there. That was bailable, but I did not grant him. In the Gambling Act. Because the gamble was very high. I did not grant the bail, then this issue was raised at very high level. So dear friends, something you can learn through the practice only. There is a difference between the theory and practice. We are here to bridge the gap between the two. If you want to be judge in Delhi or in to some extent Haryana, you will have to fill the gap between the theory and the practice. Because in Delhi, usually the questions are asked theory based though they are, but practice oriented. They will give you the problem of decided cases and you will have to decide it. If you don't decide according to the settled law laid down, but you give good reasoning, you can fetch marks. It doesn't mean you did not apply the authority or against the authority you are ordering, you are getting 0. No. Your rational thinking, your examination, your application, these are required to be applied. Open your mind. Suppose I may tell you one more practice. When the challan comes, usually either magistrate take the cognizance or will not take the cognizance. Only two things. In most of the states, FI was recorded against him. A complaint was pending before me. What I did, I issued the show cause notice. Why the cognizance will not taken against you? There is no provision. I was asked, all FIR were quashed, but my order was not quashed. Because order has not been decided something. If something is decided, then they can go. It is not decided. Whether I will make him accused or not, this is my discretion. I issue him the show cause notice. Issue show cause notice. Whether cognizance be taken or not. Every FIR was, only this order remains. Both were accused. Then I was called. What is this? There is no provision. This is my administrative power. When you have number of administrative powers, you can exercise while remaining as a judge also. This is not taught anywhere. I am telling, this is the secret of the success. What is administrative power? Administrative power grants you the discretion. It is not written anywhere. You can use it. And you can mold the things according to your, this is the crux of the matter. What I told about the happiness. Eh? Doing well and living well. And how it comes? It comes through the practice. Now comes to the charge. What is to be seen in the charge? A prima facie case. What is prima facie? How you will decide it is a prima facie case? How you will decide?
साक्ष्य ऐसे हैं कि लग रहा है कि इसने ये किया।
डाउट तो बाद में, डाउट और नो डाउट तो बाद की बात है। अभी तो प्रीमा फेसाई। व्हाट इज प्रीमा फेसाई? Again discretion comes to the magistrate or judge. He can go both way. He can discharge him and he can charge him both. It is only the training of your mind, how you will exercise that. You see, a order framed the charge, set aside the order and remanded back and asked me, he will explain what is prima facie. When the facts are invoiced, recorded, and when the facts are invoiced, this is prima facie. Means we have raw information which gives us a idea nearer to committal of the offence. Then we decide it what is prima facie. It is a criminal, you see, trial is a very grave area, very grey area. लकीर के फकीर कभी मत होना, ये बता दूं। चाहे 100 आदमी भी गए ना, अगर आपका अकेला व्यू बने, उस पर आप डटे रहना और कभी नहीं ले। Always new things. Both. Because what happens is, during the course of evidence, something comes against you. Advocate say, counsel will say, call him, take cognizance and make him accused. What you will do? Anybody can get you indulged anywhere, giving false evidence before the court. How you will come to know? He was, during the course of evidence came against him. Immediately counsel moves an application, summon him. Immediately. Then I did not take cognizance. I did not call him at all. I first issued show cause notice to him to explain. Because he is not aware of anything. Like disclosure statement, किसी के खिलाफ लिखा दो, जिसको मर्जी उठा लो, जिसको मर्जी एक्यूज बना दो, ऐसे ही वो है। किसी के खिलाफ बोल दो, उसको एक्यूज बना दो, बता दो। तो दीज थिंग्स यू विल हैव टू प्रिवेंट एंड यू विल हैव टू बी एक्स्ट्रा कॉशियस। दीज ट्रिक्स nowadays are being, criminal trial is now very challenging, I am telling you, because साइबर क्राइम इस टाइप के हो गए हैं कि आपको पूरा टेक्नोलॉजी का ज्ञान तो है नहीं, हम सबको ही नहीं है। What they commit the offense in the, you see, through the computers, but we don't know the technology. What steps are to be required? नहीं, चार्ज के बाद ट्रायल आपको पता ही है, पहले प्रोसिक्यूशन एविडेंस, फिर डिफेंस एविडेंस, और उसके बाद फिर स्टेटमेंट ऑफ एक्यूज, उसके बाद आर्गूमेंट, आर्गूमेंट के बाद ऑर्डर, एक्विटल या कन्विक्शन, ट्रायल कंक्लूड, उसके बाद आर्गूमेंट ऑन सेंटेंस। अगर कन्विक्शन हो गई है तो ये जिस्ट है, इंफॉर्मेशन से लेके इंक्वायरी का, चार्ज का, इन्वेस्टिगेशन का, ट्रायल का, ये है। ये अपने दिमाग में एक तस्वीर सी बना लो। ये 10 साल इसलिए चलते हैं, इसको एडवोकेटों का स्वर्ग कहा गया है। ये 10 साल इसलिए चलते हैं। अगर जज चाहे तो उसको कहीं भी शॉर्टकट दे सकता है। ये तो वकील का वो है, उसका हेवन है, इसीलिए तो उसको हेवन कहा है एडवोकेट्स का। एडवोकेट आगे खड़ा हो जाएगा, अच्छा अथॉरिटी आपको दोनों तरफ की मिलेंगी, अथॉरिटियां भी उसी हिसाब से जैसे मैंने बताया था आपको पहले, आपको दोनों अथॉरिटी मिलेंगी और सेम अथॉरिटी की मिलेगी। आपको सुप्रीम कोर्ट पे भी 2 अथॉरिटी मिलेगी, 4 की भी मिलेंगी, 6 की भी एक जैसी मिलेंगी, हाई कोर्ट में भी डिफरेंट व्यू, नीचे का भी डिफरेंट व्यू, क्यों नहीं हो सकता? जो जुडिशियल प्रेसिडेंट है, दो इट इज बाइंडिंग, अगर जो थोड़ा सा तुमने फैक्ट सरका दिया तो वो प्रेसिडेंट तो गया। एंड व्हाट इज फैक्ट? एनीथिंग, स्टेट ऑफ थिंग, रिलेशंस ऑफ थिंग्स, एंड अपार्ट फ्रॉम दैट एनी मेंटल कंडीशन। इसके अलावा आर्टिफैक्ट है, तो आदमी आर्टिफैक्ट के हिसाब से उसको इंटरप्रेट करता है, वहीं पे फैक्ट का और इसका डिटरमिन करके अथॉरिटी बदल जाती है। और ये प्रैक्टिकल बातें हैं। अब जिसने थ्योरी पढ़ी है वो यही आइडिया लगाएगा, लेकिन वकील तो बहुत बड़े बड़े विद्वान हैं, किताबें बड़ी बड़ी पढ़ के आते हैं, अथॉरिटी बड़ी बड़ी पढ़ के आते हैं। जज साहब को भी इतना नॉलेज नहीं होता जितना वकील साहब को। जज के पास तो अथॉरिटी है। हाँ। जहां कुछ कैदी भी नहीं चाहते कि डिसाइड हो, वो क्यों? एनआईए के अंदर मेरे थे, एक आदमी को 2 कोर्टों से फांसी हुई है, तीसरा ऑफेंस कर दिया जेल में, वो छूटना ही नहीं चाहता, उसको पता फांसी होगी, कोई हो फिर ऑफेंस कर देता है जेल में, फिर उसका ऐसे ही। तो ये एनआईए की जो कोर्ट है ना, ये थ्रू आउट इंडिया की एजेंसी की है। फांसी हुई है 2-2, 3-3 बार, ये जो टेररिस्ट ग्रुप है इनके, और उसके बाद फिर नया ऑफेंस कर देते हैं, या डिस्क्लोजर में कहीं से नाम लिखवा देंगे उस ग्रुप का, ये कर देंगे, वो कर देंगे, फिर ट्रायल। और जब वो आते हैं इतने, तो जज का तो दिमाग ही घूम जाए, इतने सारे अक्यूज होंगे, ऐसे ऐसे वकील होंगे, किसकी बात सुनोगे, कैसे करोगे? तो वो भी ऐसे केसेस में डेट मास्टर रहता है, ये यूं भी लॉन्ग है। अब इस पे ना कहीं कटिंग पॉइंट होना चाहिए। वो तो यही चाहती है ये लंबा चलता रहे, क्योंकि 200 विटनेस बना देगी, सीएफएसएल की रिपोर्ट नहीं आएगी, एफएसएल की रिपोर्ट नहीं आएगी, वो तुम्हारे हाथ में तो है नहीं। तुम 2, 3, 4 चांस दोगे, 4 डेट तो वैसी हो गई, 4-5, और केसों का अंबार है, पब्लिक बाहर भीड़ है बहुत, तो कि कब नंबर आएगा। छुट्टी लेके जाते हैं बहुत सारे, तो कि कब नंबर आएगा। वकील साहब भी कभी झके, कभी उधर जाएंगे, कभी उधर जाएंगे, कभी उधर जाएंगे। तो डियर फ्रेंड, very honest and very clear. If you want to be a judicial officer, this is your aim. You will keep these things in mind, and it is not only for the judge I am telling you, it is for the good advocate also. Advocacy is a skill. ये स्किल है और ये आर्ट है। वो जैसे मैडम जी बताती है ना जियोमेट्रिक्स, हम आपको जियोमेट्रिक्स पढ़ाएंगे। वो जियोमेट्रिक्स आपके माइंड को कैप्चर करना है कि आपकी इंटेलिजेंस कहाँ सीख करनी है, हमने कैसे लेना, क्योंकि आपके दिमाग में आपकी कोडिंग कर रखी है, आप क्या सोचोगे क्या नहीं, बचपन से ही आपको ऐसा डेवलप किया है। तो वो जियोमेट्रिक्स है, वो काम करती है। इट फंक्शंस, बट वेयर इट फंक्शंस, नॉट एवरीवेयर। जहाँ आपने अपना जो टारगेट रखा है ना दिमाग में, आप उसके हिसाब से उसको मूव करो। एक्ट एंड बीइंग एक्टेड अपॉन। एक्ट, सबसे ऊपर आदमी वही है जो एक्ट एंड बीइंग एक्टेड अपॉन करा दे, खुद एक्ट करके दूसरों से करवा दे सबसे, वो सबसे ऊपर है। चाहे वो बिजनेसमैन हो, चाहे वकील हो, चाहे वो जज हो, चाहे कोई भी हो। एक्ट एंड बीइंग एक्टेड अपॉन। और नॉलेज विदाउट एक्शन इज ए वर्थलेस एंटरप्राइज। आपको कितनी दुनिया भर की नॉलेज हो, आपने कोई एक्शन नहीं दिया ना, एक्ट नहीं की ना, तो वर्थलेस, आप बोझा ढो रहे हो। तो ये बोझा है। तो डियर फ्रेंड्स, आई कंक्लूड माई क्लास। दिस वाज एज ए प्रिल्यूड। नाउ आई विल इनवाइट ज्योति जी, सीनियर लेक्चरर ऑफ आवर faculty. Yes, please.